So you've been served with a lawsuit. What do you do? Other than that, when you're sued by an aggressive lawyer for 5 years and a sue-happy plaintiff, you have a choice. You can set up an asset protection plan so no matter what the outcome, your assets are safe. Otherwise, you can leave yourself exposed. Now, if you did lose and you did not have an asset protection plan in place and you lost all of your assets, including your home, would you have any regrets? Would you have a hard time living with that? And would you wish you'd set up an aggressive asset protection plan? And if your answer is yes, we're going to talk about what you can do to protect your assets after someone has already served you with a lawsuit. And when you watch this short video to the end, you'll know what does and doesn't work. And you'll know exactly what to do so you can sleep like a baby and your hard-earned assets are safe and secure to take care of you and your family for a lifetime. Hi, I'm the business guy, and I'm the CEO of Asset Protection Planners and Lawyers Limited, the nation's largest asset protection firm. And today we're going to talk about the #1 way, the best way to protect yourself from lawsuits after you're sued. And if you could do me a favor, please click the like button below. It'd help me out a lot so YouTube promotes this video. Thanks so much. And in the comments, tell me what you think. And you can also click the subscribe button below if you haven't already, so that when more videos come out like this one, you'll be up to date right away. Okay, so there's a lot of talk on the internet on asset protection, but who can you trust? Now, as of this video, I've been in the asset protection business for 32 years. That's since 1991. We have lawyers on staff who you can call right now and talk about your specific needs. You'll also see our website and phone number below, so you can call and fill out a free consultation form right now if you want. Now, let's talk specifics. First of all, what about an LLC or limited partnership? We have videos about LLCs, single-member LLCs, multi-member LLCs, and how they can help protect your assets in some cases. The problem is, you've already been sued. So putting your assets into a domestic limited liability company creates lots of problems. First of all, the courts would grant your opponent a fraudulent transfer ruling. Please see our video on fraudulent transfer / fraudulent conveyance, same thing. That's when somebody transfers his or her own non-exempt assets, such as cash, stock, or real estate, with intent to delay or hinder collection by a creditor. The important thing to know is it is a civil remedy only. It's not a crime in almost all states. You can't generally go to jail for it. In a handful of states, they have added fraudulent conveyance to the criminal code, but it typically deals with a very specific intent, and we know of none of our own clients who have ever crossed into anything but civil rulings. Nothing criminal for protecting assets. And as the largest asset protection company in the nation, that says a lot. So what is the takeaway from this? It's that you can't put your assets into an LLC and effectively protect them after somebody has already sued you. Likewise, you can't transfer them to mama and rely on that to protect you. You'll get absolutely creamed in the courtroom, and they will sue the family member who you transferred your assets to. And that would not be a happy time at Thanksgiving dinner. So don't pull your loved ones into your own mess. Moreover, you'll lose your assets. So don't think you can randomly transfer your assets to another person or to a U.S. company. In our vast experience studying actual case law in real courtrooms, it's not going to work. Now, what about a domestic trust? These are trusts in Nevada, Wyoming, Delaware, Alaska, and a few other states that have asset protection trust laws. What if you live in California, Texas, New York, Florida, and you put your assets into a Nevada trust? Now, you talk to promoters of these trusts, and they'll tell you anything you want to hear, but if we peel back the onion and look at the case law, these domestic trusts aren't all they're cracked up to be. First of all, if you live outside of that state, we see judges consistently apply laws to where the person is and where the assets are. So let's say you live in California, Texas, Florida. We've seen judges say, hey, I don't care if you have that trust in Nevada. You live here. So we're going to apply the law here. And U.S. judges have jurisdiction over U.S. assets. That is U.S. real estate and U.S. bank accounts, and results-oriented judges will find a way around anything they can get their hands on. Plus, if it's a matter of a U.S. judge putting pressure on a Nevada trustee, what's the U.S. trustee going to do? Give up his own assets or yours? I think we both know what the answer is. Hey, you can be the most honest guy or gal in the world, but in the courtroom, your legal enemy is bent on making you look like the devil incarnate, dripping venom off your wicked fangs. After all, that's what the opposing attorney is paid to do, and the judge doesn't know you from Adam. Since the judge sees the plaintiff's argument first, the judge's first impression impression of you is that you're an evil monster. There's no heart there. The opposing attorney may get a slice of whatever they get out of you. So there's no feeling sorry for you. The attorney on the other side feels just as sorry for you as the pride of lions feels for the baby gazelle when they're going for the kill. Hey, you're just their next meal. And in order for that contingent fee lawyer to feed his own family, he has to get paid from taking the money you worked so hard to earn. So there's no sympathy there. I cannot even count the number of clients who have told us they were in frivolous lawsuits and it was just a nuisance lawsuit and they were going to win. Their attorneys convinced them that it was a slam dunk. Like U.S. Army General Norman Schwarzkopf said, listen, it's choreographed. What happens is the orchestra starts playing and some son of a gun climbs out of the orchestra pit with a bayonet and starts chasing you around the stage. And the choreography goes right out the window. So hey, you can have all the great expectations you want, but when the bullets start flying for your head in the courtroom, the whole game changes. Now let's get specific about what does work. What will protect your assets from lawsuits after somebody sues you? Many asset protection experts agree that one of the strongest asset protection tools in the world is the international trust in the Caribbean island of Nevis or in the Cook Islands down in the South Pacific. Nevis is located southeast of Florida. Cook Islands is located due south of Hawaii. And they have extremely strong asset protection case law history. So it's not just theory, but each time we've seen it tested, it has protected our clients' assets. Now here's the important part. The reason the international trust works where the domestic ones don't is the local courts say, give me the money. Now the trustee, which is our Cook Islands or Nevis law firm, outside of the local court's jurisdiction will not comply, as your local courts do not have jurisdiction in Nevis or the Cook Islands. So here are some of the benefits. In Nevis, for example, a creditor must post a $100,000 bond with the Nevis government before bringing legal action against an international trust. Number two, unlike most countries, Nevis or the Cook Islands Trust can last indefinitely. Number three, neither place recognizes foreign judgments. In fact, only a handful of countries offer that benefit. Number four, the ordinance in Nevis allows you to combine two trusts into one or split one into two. Number five, if a creditor brings a fraudulent transfer action, they must do so within a year of the time you formed and funded the trust, or 2 years from the cause of action, or the reason why the lawsuit was filed in the first place, such as the car wreck. So 1 to 2 years in the Cook Islands. That is, once that time expires, the courts won't even hear the case. So it is in your benefit to set up the trust as quickly as possible and get the clock ticking. Number six, in the very unlikely event the creditor files quickly in Nevis or the Cook Islands, in Nevis they'll have to post a $100,000 bond, and both Cook Islands and Nevis, they must prove their case in that jurisdiction beyond a reasonable doubt with clear and convincing evidence that the settlor established the trust to keep the money from that particular creditor. That means that if the settlor set up the trust for any other reason, such as international diversification, estate planning, etc., it would be very difficult for a creditor to prevail. Moreover, in Nevis, the creditor risks forfeiting the $100,000 bond. Number seven is to hit the like button and subscribe if you haven't already. Now, trust law uses the step into the debtor's shoes theory. Whatever the debtor could do directly, the creditor can step into his or her shoes and do that same thing. So that is why it is so important that an experienced professional drafts the trust and that you have a licensed trustee, such as our firm there. Now, when we set up the trust, we want to give our clients the remote control. So the trust owns 100% of an LLC. And we usually use a NEVIS LLC, and we make you the initial manager. Now, the client is the manager of the LLC, which controls the LLC assets and is the initial signatory on the bank accounts. Your account need not be in Nevis or the Cook Islands, but can be in any financial institution in the world that offers a financial safe haven. Now, when the bad thing happens, you can temporarily have our law firm trustee step in as manager of the LLC. Now, the trustee is our licensed bonded law firm, plus they went through intensive background checks to get a trustee license. And by bonded, we mean the funds are insured. So for client safety and peace of mind, the only time our law firm steps in is when the courts would take the money. So the question is, would you rather have a 100% chance of the courts taking your money, or would you rather have a licensed bonded law firm who has never taken a client's money do what you've paid them to do, and that's protect your money? When the bad thing goes away, the string of control, which is the management of the LLC inside of the trust, goes back to you, and you're back in the driver's seat with all of your money intact. In the meantime, during legal duress, if you have bills, the trustee can pay them for you. You have online access to your money. You can do stock trades. You might even be able to have a debit card. So you still have access to your money, but your legal enemy does not. The bottom line is that everything you've worked so hard for is safe and secure. Now, the best asset protection the trust provides for is liquid assets held offshore. U.S. courts have jurisdiction over U.S. bank accounts and real estate. So for real estate, what we do is called equity stripping. We record mortgages against the property payable to the LLC. Then if needed, we have a third-party lender purchase those mortgages and place the proceeds into an inaccessible account inside of your offshore trust. Now, we set up a lot of these trusts for other law firms, and the attorneys, not us but them, charge between 30 and 60 grand. Contact us directly and we can set up a trust for a fraction of that cost. So if you have questions, you can give us a call at 1-954-400-1050 or visit us at assetprotectionplanners.com. Please like, subscribe, and share this video. See you next time. This is The Business Guy.